Good morning, and welcome to today's program, USPTO Hour, updates on subject matter eligibility under 35 U.S.C. 101. I'm Sean Hunter, the Director of the Office of Patents Stakeholder Experience here at the United States Patent and Trademark Office. The USPTO recently unveiled 7 patents business unit priorities, which are represented by the acronym INVENTS. Each priority represents the agency's commitment to strengthen the U.S. patent system, enable innovators to secure patent protection for their inventions, and provide durable patent rights that make the United States intellectual property system the best in the world. With that, it is my pleasure to introduce Charles Kim, Deputy Commissioner for Patents, Michael Kim, Vice Chief Administrative Patent Judge at the Patent Trial and Appeal Board, and Carolyn Kozowski, Senior Legal Advisor, Office of Patent Legal Administration. Charles Kim serves as the Deputy Commissioner for Patents of the United States Patent and Trademark Office. As Deputy Commissioner for Patents, Mr. Kim is an authority on patent laws, rules, and examining practice and procedure, and provides executive leadership to the Office of Petitions, the Office of Patent Legal Administration, the Office of Patent Quality Assurance, the Central Reexamination Unit, and the Manual of Patent Examining Procedure staff. Prior to becoming Deputy Commissioner, Mr. Kim served as Acting Assistant Commissioner for Patents and prior held the position of Director of the Office of Petitions. He has also served as a Senior Advisor to the Deputy Commissioner for Patents, Examination Policy, and as a Supervisory Patent Examiner and Technology Center, or TC 2100. In addition, Mr. Kim currently leads the USPTO's Artificial Intelligence, or AI, and Emerging Technologies Working Group. In this capacity, Mr. Kim provides executive leadership to a cross-cutting team of AI specialists from across the agencies that develops and implements various AI and IP policy initiatives at the USPTO, including the AI and Emerging Technologies Partnership. Mr. Kim earned his Bachelor of Science in Electrical Engineering with high honors from Rutgers University and his Juris Doctor from George Washington University Law School. Mr. Kim also holds an Executive Certificate in Public Policy from the Harvard Kennedy School. Appointed in 2020, the Honorable Michael Kim serves as a Vice Chief Administrative Patent Judge for Operations at the Patent Trial and Appeal Board, or PTAB, at the United States Patent and Trademark Office. Judge Kim was appointed as an Administrative Patent Judge in 2011 and as a lead judge in 2013. Prior to his appointment, Judge Kim was a patent attorney for the PTAB. Judge Kim has significant experience in conducting inter parte reviews and post-grant reviews under the American Invents Act and reviewing adverse decisions of examiners upon applications for patents. He works primarily in the business methods, mechanical, and electrical technology areas. In addition to continuing to serve on panels as an APJ, his current executive responsibilities include managing the PTAB's workload inventory, overseeing various PTAB committees and special projects, and coordinating PTAB policy in certain subject matter areas. Prior to joining the USPTO, Judge Kim was a patent attorney at an intellectual property law firm in Washington, D.C., where he focused on patent prosecution and client counseling. Judge Kim received his law degree from the Duke University School of Law, where he was a founding member of the Duke Law and Technology Review, and a Bachelor of Science degree in Mechanical Engineering from the Massachusetts Institute of Technology, where he also holds concentrations in economics, political science, and writing. Carolyn Kozowski is a Senior Legal Advisor in the Office of Patent Legal Administration, or OPLA. In this role, she assists in the drafting of rule packages, memoranda, and associated guidance to implement USPTO initiatives and comply with developments in patent law, including those regarding subject matter eligibility, designs, and 35 U.S.C. 112. Prior to joining OPLA, Ms. Kozowski was a primary patent examiner and examined patent applications related to network security and business method technologies. Previously, she worked as a patent agent and patent attorney for a large general practice law firm in Washington, D.C. Ms. Kozowski received her B.S. in Systems Engineering from the University of Virginia and her Juris Doctor from the George Washington University School of Law. With that, it's my absolute pleasure to turn it over to you, Charles, Michael, and Carolyn.
Great. Thank you so much, Sean. And hello, everyone. As Sean mentioned, my name is Charles Kim, and I am the Deputy Commissioner for Patents here at the USPTO. And I'm joined by my colleagues, Judge Kim, no relation, from the Patent Trial and Appeal Board, and Carolyn Kozowski from the Office of Patent Legal Administration. And we're here today to talk about patent subject matter eligibility, or 101. So this slide shows the agenda for today's presentation. So I'll kick things off by discussing our current subject matter eligibility guidance. Then I'll give some background and a high-level overview of the 101 reminder memo that we issued this past August, and then I'll turn it over to Carolyn, who will discuss that memo in more detail. After Carolyn, Judge Kim will discuss the recent Appeal Review Panel, or ARP, decision in ex parte Desjardins, which was just made precedential yesterday. Judge Kim will also discuss the delegated rehearing panel decision that we issued earlier this year that's currently on appeal to the Federal Circuit. And I believe we'll have some time afterwards for some Q&As. So starting with our current guidance. So our current subject matter eligibility guidance is primarily based on the guidance that we issued in January of 2019, which we refer to as the 2019 PEG. The 2019 PEG has been incorporated into the Manual of Patent Examining Procedure, or MPEP, specifically MPEP 2103 to 2106.07. More recently, last July, we issued an update on our subject matter eligibility guidance to address innovation in critical and emerging technologies, especially AI. This update builds on the previous guidance that I mentioned and includes discussions of recent Federal Circuit decisions on subject matter eligibility that may be relevant to AI technologies. And it also addresses feedback that we heard from our stakeholders. The guidance update also announces 3 additional examples that are designed to assist USPTO personnel in applying our subject matter eligibility guidance to AI inventions during patent examination, appeal, and post-grant proceedings. So that's a high-level overview of our current guidance. Before we move on to the next slide, I did want to mention that during the recent AIPLA annual meeting, Director Squires shared his vision on 101, and he's made it clear that the USPTO's door is wide open to transformative technologies such as AI. And as you'll hear today, we've already taken some steps to move in the direction that Director Squires has laid out for us. In addition to these steps, we're currently evaluating our current subject matter eligibility guidance to ensure alignment with the Director's vision. And we welcome any feedback that you may have on our guidance. All right, so next, I'll give some background on the 101 reminder memo. So after we issued the 2019 PEG that I just mentioned, the 101 rejection rates dropped significantly across all of the technology centers, or TCs. And this was expected. That's what the guidance was intended to do. And since then, for the most part, the 101 rejection rates have remained relatively stable. However, in recent years, we found that in certain TCs, the 101 rejection rates have gone back up. And this is something that we identified as part of our broader efforts to improve patent quality by analyzing outlier trends. So what we did was we took a deeper dive into these TCs, and we found some common themes. And the 101 reminder memo was developed to address those themes. So this past August, we issued a memo to examiners that includes reminders about important aspects of our current subject matter eligibility guidance. The memo was addressed to 3 TCs, TCs 2100 and 2600, where many software and AI technologies are examined, as well as TC 3600, which examines business methods. And although the memo was addressed to these 3 TCs, it was sent to the entire examining corps, including all 8,000 plus examiners, as well as all of our SPEs across the TCs. I do want to point out that the memo is not intended to announce any new practice or procedure and is meant to be consistent with our existing guidance. So at a high level, the memo focuses on Step 2A of our existing subject matter eligibility guidance. And most of you may know, Step 2A asks if the claim is directed to a judicial exception. Step 2A has two prongs. For the first prong, you evaluate whether the claim recites a judicial exception. And if the answer is no, the claim does not recite a judicial exception, then the 101 analysis ends there and the claim is eligible. However, if the claim does recite a judicial exception, then you move on to the second prong, where you determine whether the claim as a whole integrates the judicial exception into a practical application. The memo includes reminders for both prongs. For prong 1, the memo explains that the mental process grouping of abstract ideas is limited and should not be over-applied. It also explains how to distinguish whether a claim recites a judicial exception or merely involves a judicial exception. And this is something that has been a point of confusion for some of our examiners. For prong 2, the memo reminds examiners to consider the claim as a whole when determining whether there is a practical application. It cautions examiners not to oversimplify the apply it consideration. Also, it reminds examiners that the improvement to technology does not need to be expressly called out or named in either the claim or the specification. Lastly, the memo also includes important reminders about when to make or not make a 101 rejection. And it points out that the tie goes to the applicant under the preponderance of the evidence standard. So that's a high-level overview of the memo. I hope I didn't steal too much of Carolyn's thunder. Next, I'll turn it over to Carolyn, who will discuss the memo in more detail.
Thank you, Charles. So the first section of the memo does discuss the mental process grouping of abstract ideas. Examiners frequently encounter this grouping, especially in computer-related arts. And so a reminder on the USPTO's guidance, the MPEP instructs examiners to determine that a claim recites a mental process when it contains limitations that can practically be performed in the human mind. The MPEP, the USPTO issued examples, and the Artificial Intelligence Subject Matter Eligibility Update that was issued in 2024 have many examples of claims that do and do not recite mental processes. The memo reminds examiners that there are limits on the mental process grouping, and the memo specifically points out that claim limitations encompassing AI in a way that cannot practically be performed in the human mind do not fall within the mental process grouping. One issue that can arise in computer-related inventions, especially AI, is that there is terminology that can sound like it is referring to mental processes, even when it could be unreasonable to interpret it that way. For example, we say that large language models can hallucinate when they produce nonsensical or inaccurate information, but that is not the same as a human being experiencing hallucinations or experiencing something that isn't real. So examiners should only find that a claim limitation recites a mental process when that limitation can reasonably be performed in the human mind, and that determination requires a careful claim interpretation that is reasonable. So the memo does remind examiners to be careful in distinguishing claims that recite an exception, which do require further eligibility analysis, from claims that merely involve an exception or are based on an exception, which are eligible and do not require further eligibility analysis. The USPTO's guidance does define in the MPP what it means to recite a judicial exception. Claim recites a judicial exception when a law of nature, natural phenomenon, or abstract idea is either set forth or described in the claims. And the MPP does provide definitions of set forth and describes. So a claim sets forth a judicial exception when it's explicitly stated in the claim, and a claim describes a judicial exception when that limitation expresses the judicial exception without explicitly naming it. So a good example of that is the Alice decision. The claims in that case didn't actually say intermediated risk settlement. They didn't explicitly use those words, but the claims describe the concept of intermediated risk settlement. So we did receive questions on the differences between example 39 and example 47. So example 39 is drawn to facial recognition technology. That was an example that came out in January of 2019 with the 2019 PEG. And example 47 is an example that was issued in July of 2024, and that was drawn to training a neural network to predict anomalies. The two examples in the MPEP are instructive on the point of the merely involves or based on an abstract idea versus the concept of reciting an abstract idea. So on the right, you have a claim there that recites a judicial exception. The claim is a machine comprising elements that operate in accordance with F equals ma. It's a simplistic claim, but it does set forth the principle that force equals mass times acceleration, and therefore that claim is considered to recite a law of nature exception. Because F equals ma is also a mathematical formula, the claim could alternatively be considered as reciting an abstract idea. And then on the left, you have an example of a claim that merely involves or is based on an exception. And there the claim is based on the concept of a lever pivoting on a fulcrum, which involves the natural principles of mechanical advantage and the law of the lever. So it's also based on math as well. So this claim is not considered to recite natural principles or mathematical concepts, and therefore it would not be considered to be directed to a judicial exception and would be eligible without further inquiry. However, the claim on the right that does recite a judicial exception, that would require further analysis under Step 2A, Prong 2. So while the two training limitations on the previous slide may appear to be similar, the limitations illustrate important points about the USPTO's guidance. First, breadth is not ineligibility, so you can have both broad and narrow claims that could be either eligible or ineligible. And second, the training limitation in example 39 does not consider to recite a judicial exception. There is no judicial exception explicitly stated in the training limitation, so it doesn't set forth a judicial exception. And in addition, the training limitations encompass a broad array of techniques and/or activities, so the limitation does not merely describe a series of mathematical calculations using other words. So while it may be involved or based on a judicial exception, it doesn't recite one. So under the USPTO's guidance, where a claim doesn't recite a judicial exception, it would be considered to be eligible. The critical difference in example 47 is not the breadth of the claim, but that the limitation sets forth mathematical calculations by name. So in other words, this claim does explicitly require mathematical calculations, and therefore it's considered to recite an abstract idea. Okay, so moving on to reminders on Step 2A, Prong 2. The memo does remind examiners that they should consider the claim as a whole under Step 2A, Prong 2, and that they should consider the limitations containing the judicial exception as well as the additional limitations in the claim. Those need to be considered and evaluated together to determine whether the claim integrates the judicial exception into a practical application. And there are a couple of reminders there that you can see. One is that the additional elements in the claim shouldn't be considered completely separate from the judicial exception, and that examiners should also consider how those limitations interact and impact each other when evaluating whether the exception is integrated into a practical application. If the claim as a whole is integrated into a practical application based on an evaluation of the considerations that we have in the MPP, particularly MPP 2106.04D, then those additional limitations are considered to impose a meaningful limit on the judicial exception, and the claim would be eligible. Diamond v. Deere is a good example of a case where the additional steps of the process integrated the judicial exception into the process as a whole. The claim in Deere did not merely recite calculating a cure time using the Arrhenius equation in a rubber molding process. Instead, there were specific ways of gathering the data for input into the Arrhenius equation, and then the data from that equation was used to control the rubber molding process. So the Supreme Court looked at the Arrhenius equation and the other steps, including opening the mold, together and finding the claim to be eligible. The discussion of the improvements consideration is included in the memo because often claims are found to be eligible in computer-related technologies like AI because the claim reflects an improvement to the functioning of a computer or to another technology or technical field. The memo does have a brief discussion of how the improvements analysis is performed and points examiners to the guidance in the MPP on improvements. There is extensive discussion in the MPP on this particular consideration. The memo cites to numerous Federal Circuit cases on improvements as examples of claims that cover a particular solution to a problem or a particular way to achieve a desired outcome, which are eligible, as opposed to merely claiming the idea of a solution or outcome, which are not typically eligible. And that's one way that the improvements consideration is characterized. A few things to highlight. There's a reminder for examiners on how to evaluate improvements. So first, they should look at the specification, should be consulted to determine whether the disclosed invention improves technology or technical field. And second, if the specification does set forth that improvement, then the claim itself has to reflect that disclosed improvement. The claim must include the components or steps of the invention that provide the improvement described in the specification. So under the USPTO guidance, one of the considerations that examiners do take into account when determining whether a claim integrates the judicial exception into a practical application is whether the additional elements amount to more than a recitation of the words apply it or are more than mere instructions to apply the exception on a computer. If they do amount to more, then the claim is considered to be eligible. The memo does emphasize the distinctions between the apply it consideration and the improvement consideration, and that the two considerations do overlap. The memo explains what examiners can look at when evaluating those considerations. Many of those may be familiar to you. They are found in MPP 2106.05F. For example, examiners can look at whether the claim recites the idea of a solution or outcome, which can render a claim ineligible, or whether the claim recites a particular solution to a problem or a particular way to achieve a desired outcome. And that, again, overlaps with the improvements consideration, which also looks at that. The claims in McRow, those described a specific way of using rules to set morph weights and transitions to solve a problem in computer animation. So that's a good example of where the claims described a specific way to solve a particular problem. The memo does caution examiners not to oversimplify claim limitations and expand the application of the apply it consideration. And it does remind examiners to consider whether the limitations recite a tool to improve the recited judicial exception, or whether the claim as a whole provides an improvement to technology like we have in EnFish and McRow. And then finally, the memo does compare the recent Federal Circuit decision in Recentive with example 47, claim 3. The claims in Recentive did recite steps that were considered to be incidental to automating the abstract idea, which was not enough to render the claims eligible, as opposed to the limitations in the USPTO's recent example 47, claim 3, which was directed to a technological improvement in network intrusion detection. And then finally, the memo does remind examiners that to reject a claim under any statute, unpatentability has to be established by a preponderance of the evidence. So a rejection of a claim should not simply be made because an examiner is uncertain about the claim's eligibility. If it is a close call, examiners are reminded that they should only make the rejection when it is more likely than not, so more than 50%, that the claim is ineligible under 101. And finally, there's a reminder to practice compact prosecution, so that is to address all of the patentability requirements in the first office action. And then this slide shows our subject matter eligibility resources. And so on these pages you can find, or the first link there, you can find our guidance and training materials. And then the link below gives you the location of the MPP. Turn it over to Judge Kim.
Thanks very much.
And it's always a pleasure to work with my colleagues from patents on these important issues. And I will say, Charles stole my line about not being related, so maybe we're more alike than we think. But anyways, so on to the discussion itself. I'd like to start off sort of the context of Ex parte Desjardins and sort of the atmospherics surrounding this decision. And as alluded to by Deputy Commissioner Kim, it includes some very recent related events. As he noted, the decision yesterday was designated precedential. And in a subscriber alert announcing the decision, a link was actually provided to remarks that Director Squires made at the AIPLA annual meeting last Friday. And you can go find that if you go to the USPTO webpage, and under About Us, go to News and Updates. And in those remarks, he sets forth his 3 pillars of eligibility, namely 35 U.S.C. Section 100B, the Federal Circuit's 2016 EnFish decision, and, quote, something more, something morse, end quote. And promised additional guidance was forthcoming on the issue of patent eligibility. So the subscriber alert yesterday states that Desjardins does highlight one of the ways the office is fulfilling the director's promise under those three pillars of eligibility. And if you didn't receive it, that may be a reason to go to our USPTO website and subscribe to anything that may be of interest to you. So on to the case at hand. Um, the Desjardins case concerned a computer implemented method of training machine learning models on multiple tasks, such that once the model has been trained, the model can be used for each of multiple tasks with an acceptable level of performance. And go into the specification in that case, it does state that the machine learning models trained on multiple tasks may lose knowledge of previous tasks when a new task is learned. And this is something in the industry called catastrophic forgetting. And the invention addresses this risk. In particular, according to the specification, it states that by training the model on a new task, by adjusting the values of the parameters of the model to optimize an objective function that depends in part on how important the parameters are to the previous learned tasks. The model can effectively learn new tasks in succession while providing and protecting knowledge about previous tasks. So that was a lot, but as we know, the name of the game is a claim. And so we have independent one in that case set forth here. And I'll note that this is a method claim, and this certainly seems to fit under the process of section 100B, which, has the director noted, has sort of been included in all US patent law since 1793. So I'll note here that we have two limitations italicized, and I really need you to keep these in the back of your mind as I talk about the appeals or review panel decision, which focuses on 101, but these italicized limitations are the main limitations at issue in the 103 rejection that came from the core and was addressed by the board. And in a bit of a spoiler, the board's findings on that 103 rejection with respect to those limitations sort of remain undisturbed. I also bring to your attention two other limitations in the ARP decision. The first is what I'll call the computing limitation, as it's the paragraph that begins with that word. And in particular, the limitations to focus on are computing an approximation of a posterior distribution over possible values of the plurality of parameters. The second limitation are what I'm going to term the adjust limitations, which is in the limitation that starts with the word training. Later in the paragraph, it reads in a relevant part, quote, to adjust the first values of the plurality of parameters to optimize performance of the machine learning model on the second machine learning task, while protecting performance of the machine learning model on the first machine learning task. Okay, so what happened here? So as I mentioned before, during prosecutions, the claims were finally rejected under Section 103 on obvious grounds. And on appeal, the board did affirm the 103 rejection, although I will note that there was a dissent in part there. And then the board panel also entered a new ground of rejection under Section 101, in particular, determining that the independent claims were, quote, directed to patent ineligible abstract concept of training a machine learning model or algorithm on multiple machine learning tasks sequentially, end quote. So in that case, the appellant requested panel rehearing, and on rehearing, the panel, which actually included a new judge due to the unavailability of one of the original panel member, declined to modify its determination. So at that point, an appeals review panel, which at the time identified myself, acting Commissioner Valencia Martin Wallace, and actually due to the recusal of acting Director Coke Stewart at the time, Senior Lead Administrative Patent Judge Michelle Ankenbrand, was convened sua sponte to review the new ground of rejection under Section 101. And following the confirmation of Director Squires, a superseding order was issued in that case that reconvened the appeals review panel, but with the director replacing Senior Lead Judge Ankenbrand. So that appeals review panel issued a decision on September 26th that was authored by Director Squires. It vacated the Section 101 rejection and concluded that the claims were eligible. The decision agrees with the board panel that although the claims recite an abstract idea, here in the form of a mathematical concept, the appeals review panel also determined that the claims additionally reflected an improvement in how the machine learning model itself operates. And in particular, the decision discusses how the portions of the specification that I spoke about earlier identified improvements in training the machine learning model itself and how the adjust limitation I referenced reflects that improvement. So the portion of the appeals review panel decision here highlights one of the pillars of the director's stated philosophy concerning subject matter eligibility, namely the Federal Circuit's NFIS decision. And in particular, the decision highlighted NFIS's holdings that just like how improvements to hardware, which are defined by physical features, can denote improvements to computer functionality, so can software, which is defined by logical structures and processes, and indeed, that software can constitute as much of an improvement in computer technology in the real world. Now, the decision additionally cautioned that examiners and the board should not evaluate claims at too high a level of generality, lest that they equate any machine learning with an unpatentable quote-unquote algorithm and categorically exclude AI innovations from patent protection, even if they were adequately described and not obvious. And describing his something more pillar, Director Squires drew parallels to what was, in his view, at the time, transformative, famous, and life-changing technology in Samuel Morse's telegraph that issue in O'Reilly v. Morse, and AI technology today. And in particular, he mentioned the contrast between Claim 8, which was at issue in Morse, and recited electromagnetism and was not held eligible, but then Claim 5 or Claim 3, depending on who you ask, and the dot and dash system that was devised to transmit the alphabet electromagnetically over the wire, which was held to be eligible. So in any case, we all know that each limitation in a claim was put there by you, the practitioners, as a reason and should be considered, whether it be for obviousness, for written description, or subject matter eligibility. So in that regard, the appeals review panel decision explicitly addressed that it did not disturb the rejection under 103 that was affirmed by the board. In the panel's view, sections 102, 103, and 112 are the traditional and appropriate tools to limit patent protection to its proper scope, and that those provisions should, quote, be the focus of examination. Okay, so that's it for now for Desjardins. I will now talk about the delegated rehearing panel decision in Crusoe. So this came up in a post-grant review, or PGR, and for those who are not as familiar, while inter partes review positions are limited to challenges based on anticipation and obviousness based on patents and permitted publications only, PGR petitions also permit challenges based on subject matter eligibility, indefiniteness, and other issues, with the trade-off, of course, being that with more statutory bases available in post-grant review, they can only be brought very early after the patent issues. And I also want everyone to keep in mind that because this is a case where the board is resolving an inter partes dispute between two third parties, the burden is always on the party bringing the challenge to prevail in all respect. So again, I ask that you keep that in mind as you read this decision. All right, so what was at issue in Crusoe technology-wise? So this involved a system for powering a blockchain mine at a remote gas facility. And the claim recited, among other things, a gas source, a generator, and blockchain mining device, which in turn
though that included a processor and network components. So in the final written decision, in that post-grant review, a board panel determined that independent claim 1 was not eligible because they were directed to the abstract idea of using natural gas power to power a blockchain mine, and further reasoned that the idea of capturing otherwise wasted energy in order to generate power to improve profitability is a fundamental economic practice, namely to find a low-cost source of resources to increase profits. I'll note that that was for independent claim 1, but there were many dependent claims also challenged in that proceeding that were not found ineligible. And this is where the burdens I talked about matters, because in the board panel's view, the petitioner provided only a conclusory analysis related to those dependent claims and did not adequately articulate why they were ineligible under 101. So procedurally, then Acting Director Stewart, sua sponte, initiated a director review of the board's final written decision and delegated it to a delegated rehearing panel to determine whether the Section 101 unpatentability decision was appropriate. And the DRP decision determined that the petitioner had not met its burden of showing that the claims were ineligible because it had not identified any language in the claim that recited an abstract idea. The panel there reasoned that the claim doesn't describe a result or effect that is itself an abstract idea, but instead claimed a machine and its constituent parts. So this case is currently on appeal to the Federal Circuit, so we may get some answers from our reviewing court on their view of this decision. And before I end, I'd just like to thank Lead Judge Charles Boudreau for his assistance in helping me prepare these materials and remarks. It was invaluable, and I really couldn't have done it without him. Back to you.
Great, thank you, Judge Kim. So I'll close out today's presentation by going over some key takeaways. So again, the 101 Reminder Memo was issued as part of the USPTO's broader efforts to improve quality by analyzing outlier trends. The memo does not announce any new practice or procedure, but rather reminds examiners about important aspects of our current subject matter eligibility guidance. The ARP decision that Judge Kim discussed in ex parte Desjardins makes it clear that AI inventions that reflect an improvement to technology, such as improvements to how a machine learning model operates, are eligible. The ARP decision also emphasizes that sections 102, 103, and 112 are the traditional and appropriate tools to limit patent protection to its proper scope. Lastly, as I mentioned before, we're currently evaluating our current subject matter eligibility guidance to ensure alignment with the director's vision, as Judge Kim articulated so well. And as we evaluate our guidance, we welcome any questions, thoughts, and suggestions that you may have on our guidance. So stay tuned. I believe the next slide includes an email address where you can submit your questions and suggestions about our guidance. So if you do have any feedback, please use that email address and reach out to us. Sean?
All right, well, let me first say thank you to each of you for taking time out of your busy schedule to be with us today. We have reached our question and answer segment of today's program. As a reminder, questions were taken in advance. If you have questions that you would like to ask of our speakers today, please feel free to use the USPTO hour at uspto.gov inbox. And with that, we'll go ahead and get started with some of the questions we've already received. Let's see. I recently had an interview with an examiner where the examiner indicated that the 101 Reminder Memo does not apply to them. Can you clarify if this is true?
I can take that one. So as I mentioned earlier, while the Reminder Memo was addressed to 3 specific TCs, it was sent to the entire examining corps as well as all of our SPEs. And the memo provides instructions and guidance to examiners. So examiners are expected to follow what's in the memo. What we did was when we issued the memo back in August, we trained the POCs in each of the technology centers. We are currently working on training for examiners, and that training will include training on both the 101 reminder memo as well as the ARP decision that Judge Kim discussed.
All right, thank you so much for that. Which leads me to another question we received. I haven't heard of the ARP before. Is that something new or something you can share information about?
Yeah, thanks very much, Sean. So as spelled out on slide 22, the ARP stands for an Appeals Review Panel. And that panel and process was established by the office on July 24th, 2023. And there is additional information about it on our webpage. But really in brief, it's a panel that can be convened by the director at his or her sole discretion, and it conducts sua sponte review of PTAB decisions in ex parte appeals and reexamination, as well as reissue appeals. And unlike director review of decisions arising in inter partes or post-grant reviews under the AIA, those can be requested by the parties. Requests for ARP review are not accepted or considered at this time. The ARP is only convened sua sponte. And like other PTAB panels, the ARP consists of 3 members by default. It includes a director, the commissioner of patents, and the chief judge of the PTAB. But there are other individuals that can be substituted in as well, including myself, who does not hold any of those positions. And we follow all the other processes in the office in deciding cases and rendering panel decisions. So like I said, there's more information on the webpage if people are interested.
All right, thank you for that answer. Very helpful. Let's see what else we have here. Will examiners be trained on the 101 reminder memo and appeals review decision in ex parte Desjardins if they have not been already?
Yeah. So as I mentioned in response to the previous question, we are currently developing training material on both the 101 reminder memo as well as the ARP decision, and this is going to be for examiners. We're expecting to have that delivered later this year. And as we do with all of our training material, once we deliver the training, we will make that training material available to the public on our webpage.
All right, thank you for that. Does the presidential designation of this decision mean that PTAB panels will no longer be permitted to enter new grounds of rejection under Section 101?
Yeah, thanks, Sean.
Sure.
That's a very good question. The short answer is no. So each case appeal is decided on its own fact. And there certainly can be other scenarios in which a new ground under Section 101 may be appropriate. It is set forth in our rules for ex parte generally under 4150 regarding new rounds of rejection. And certainly in cases where a claim does recite a judicial exception, like the example set forth in the ARP decision, but unlike that decision, does not integrate that exception into a practical application under step 2A prong 2 that was very comprehensively set forth today by my colleagues from patents.
Okay, thank you for that, Judge Kim. Let's see, in the August 4th memo, there is language that says the claim itself does not need to explicitly recite the improvement described in the specification. Can you clarify or speak more to what is meant by saying that the claim does not need to explicitly recite the improvement?
Yeah, so what we're getting at there is that the claim doesn't need to say the improvement is, or to recite the specific improvement. For instance, improving the network capacity. That does not explicitly need to be recited in the claim, but the steps or components that do reflect the improvement that is in the specification, that needs to be in the claim.
Okay, understood. Thank you for that. Is the USPTO planning to issue any additional examples on 35 U.S.C. 101?
Yes, so as you're probably aware, we do have 49 examples. They do cover a wide range of technology, from software to methods of treatment to diagnostics to business methods. We are considering additional examples, so we would welcome your thoughts and suggestions on technologies or issues that you think should be addressed in the additional examples. I think that would be helpful for us to consider. You can share your thoughts and suggestions at that email address that was provided at the end, 101@uspto.gov. We recently did issue the appeals review panel decision in ex parte Desjardins, which is an example of an eligible core AI technology that does improve the AI technology itself. And we're continuously open to nominations to designate decisions from the board, either precedential or informative. I don't want to speak on behalf of Judge Kim, but if anyone does identify any decisions, you can certainly follow the procedures. I assume they're on the website as to how to submit those to us if there's any that you would be interested in seeing be informative or precedential.
Thank you so much for that. I've heard you guys mention DRP and ARP. How is the DRP different from the ARP?
Yeah, thanks for that, Sean.
Sure.
So the DRP stands for Delegated Rehearing Panel, and the DRP was created at the same time as ARP, but it serves a different role. In particular, again, while the ARP is sort of convened sua sponte to review decisions in appeals and reexaminations and reissues, a DRP is convened pursuant to 37 CFR 42.75F. It's only in AIA trial proceedings and derivations, and it's only after the director has initiated director review sua sponte or granted a party's request for director review. So again, all that information is available on our website if you look for delegated rehearing panel. And as you can see, as noted by the Crusoe decision, the board in AI trials does address Section 101 eligibility sometimes, and certainly in appeals, there are many, many decisions where the board does address 101.
All right. Thank you so much, Judge Kim. There appears to be significant variability among examiners and art units in how patent eligibility of machine learning inventions is assessed. Does the USPTO have any plans to promote greater consistency in this area?
So thank you, Sean. So that's a great question. I think consistency is always a challenge, right? When you're talking about 8,000 plus examiners examining over, hundreds of thousands of applications in a very complicated area of the law, such as 101. So it is a challenge. That being said, we are taking steps to address that challenge. I mentioned that the 101 reminder memo was part of our broader efforts to improve patent quality by analyzing outlier trends. So in addition to analyzing the 101 rejection trends that led to the reminder memo, we are also looking at other outliers as well. And this is something that the technology centers have previously done, right? So they look at different data in their TCs to analyze outliers. This year, we are having our Office of Patent Quality Assurance, in addition to the 12,000 random reviews that they conduct every year, and we are planning to have them look at outlier trends, including areas where there may be very low allowance rates, as well as areas where there may be very high allowance rates. So that's one example of some of the outlier trends that we will be looking at for this fiscal year.
All right, thank you. Let's see. Have there ever been any other ARP decisions? I'm guessing this is for you, Judge Kim.
Sure. So there has been one other ARP decision. It was ex parte Chamberlain, and it issued, I believe, last year in May. And it's, to me, an interesting decision. It regarded an analysis of Jepson and mean plus function claims in the biotechnology space. So, that's not something I think that really happens often at the office. And that one did have, at the time, in last year, the director, the commissioner for patents, as well as the chief judge.
Thank you for that, Judge Kim. Let's see. Can you explain, this is in reference to example 47, and I think example 47 is tied to mathematical calculation. Can you explain or clarify why the algorithm in example 47 is considered a mathematical calculation? Is any algorithm, this is, I guess, a two-part question, so pardon me, is any algorithm considered a mathematical calculation?
So the short answer, I think, would be that it would depend on the facts of the case as to whether the algorithm is necessarily considered to be mathematical. I think in example 47, it came down to the claim interpretation in that specific case. And in that specific claim, I think it recited the backpropagation algorithm and the gradient descent algorithm. And so those were interpreted as reciting mathematical concept. So it really came down to the facts of the case, and as I talked about earlier, giving a careful claim interpretation, broadest reasonable interpretation in light of the specification.
So it'd be fair to say it depends.
Yes.
Okay, gotcha. Let's see. What is the USPTO doing to protect against overly broad and result-oriented claims in patent applications?
So I can take that one.
Sure.
Sean. So as I mentioned, we have OPQA do random reviews, thousands of random reviews every year. We have also recently increased the number of reviews that our supervisory patent examiners or our SPEs do. So they are reviewing more office actions from all of their examiners, and they're also reviewing office actions from the full signatory as well as partial signatory examiners as well. So we are reviewing a lot more office actions to ensure that we're protecting against overly broad claims and that may be result focused. So that's one way that we're doing that. Also, as Judge Kim discussed in the ARP decision, Director Squires pointed out that that 102, 103, and 112 are the traditional and appropriate tools to address and to limit patent protection to its proper scope. So those are areas that, in addition to evaluating our current subject matter eligibility guidance, those are areas that we will be focusing on as well.
All right, thank you so much for that, Charles. Let's see, what else do we have here in our live questions that are coming in? The touchstone of eligibility seems to have become whether or not the invention constitutes a technical improvement. Are there perhaps any other ways to find eligibility?
Yes, so there are other considerations that examiners evaluate. I think in this particular context, because we were talking about AI inventions and computer-related technologies, that lends itself to the improvements consideration, but the MPEP does have other considerations that examiners evaluate in Step 2A, Prong 2, and Step 2B, including particular transformation, particular machine, and other meaningful limitations that do limit the judicial exception. So those considerations are also evaluated when they're looking at subject matter eligibility.
All right, thank you so much for that, Carolyn. I feel like you guys sort of already touched on this, but I'll ask it just in the interest of clarity. Will the USPTO be providing additional training to examiners on evaluating patent eligibility for AI/ML claims?
Yes, we will. And
Okay.
again, that the training material, once we've trained our examiners, the training material will also be available on our webpage.
All right, thank you so much for that. Let's see, what else do we have here? This is actually not a question. Well, I guess it is a question. Let's see. Do people typically cheer after these seminars? I'm reading this verbatim because this one was A plus plus plus. If I'm reading that correctly, there are 3 pluses here in both style and substance. You are presently getting a standing ovation in New York City. So they are very appreciative. And this one literally just came in. Can anyone speak to where do smartphone applications fit in the scheme and rules for subject matter eligibility? I'm not sure I follow there, so this is verbatim how the question is phrased.
Yeah, so I can take that one, and Carolyn, Judge Kim, please feel free to weigh in. So we don't have any special rules for certain types of technologies, right? So our subject matter eligibility guidance that we discussed today would apply to smartphone technologies. Obviously, in addition to 101, we would review the application, the invention, to make sure that's it's compliant with the other statutes as well, namely 102, 103, and 112. Anything further to add?
I would just add there's no categorical categorical exclusions of subject matter, which they raise, I think, in the Desjardins decision. So they're all evaluated using the same framework under 101.
All right, thank you so much. Let's see. Is there a timeline for the review and evaluation of current guidance to assure alignment with the director's vision? I think, as mentioned earlier in the presentation, and I think you may have answered this, but just a timeline for any revisions to current eligibility guidance.
Sure. So we don't have any specific timelines at this point.
Sure.
This is something that we're actively evaluating. As Judge Kim mentioned, the director has made it clear his views on 101. So we will be evaluating our guidance based on any feedback that we received. So again, to make sure that we are fully aligned with the director's vision.
All right. Thank you so much for that. Can you clarify how the office determines whether technical elements in a computer implemented claim are considered conventional or generic?
In step 2B, I assume they mean. So conventionality, so first of all, if they're asserting that something is conventional, so such as a computer component, they would need to evaluate at step 2B. They need to provide evidence to support that.
Sure.
So they have to have factual support to evaluate whether something is well understood, routine, and conventional. So for a computer component, if they are asserting that, the examiners, then they would need to provide something in maybe a patent publication or patent. They could take official notice, I believe. And then there's a number of other ways that are outlined in the MPP.
Okay, thank you for that. It looks like we are absolutely out of time at this point, right at 1 o'clock on the dot. So let me first say thank you again to all of our speakers for joining us today, taking time out of your busy schedules. Thank you to all of you for joining us, taking time out of either your morning or your afternoon. As a heads up, a post-event survey will be sent to the email address in which you use to register for this event. We absolutely would appreciate if you take the time to fill that out. Good, bad, or otherwise, we appreciate the feedback. We use it to inform this event and other initiatives here at the agency. So with that, if you do have any additional questions, I suggest using the email address provided during the presentation, which is 101@uspto.gov, or any other questions you can send to usptohour@uspto.gov. With that, we're going to say have a great rest of the day and week, and we'll see you somewhere soon.